Hi, my name is Rob.
And I'm Sarah, and we were team members on the 2021 Jessup World Champion team. In this video, we'll be explaining to you how to deliver oral appearances.
So what are oral submissions? Oral submissions are the oral advocacy component of a moot, and it gives you the opportunity to develop on your written submissions, as well as, if you are the respondent, to rebut the submissions of the appellant or plaintiff, depending on the case. Depending on the particular competition that you're in, you may have anywhere between 15 to 25 minutes to make your oral submissions. You also may have a right of rebuttal or surrebuttal, depending on the structure of the moot. The first person to give their submissions will always be the senior appellant or senior plaintiff, followed by then potentially the junior counsel for the applicant side, or also the senior counsel for the respondent side. That will depend on the structure of the moot, and it's important that you work out what that structure is going to be before you begin the moot, so that you're not surprised when you're called on early by the judge.
To manner. The best way to think about oral submissions is that it is a conversation with the judge about the law. Although you should remain formal, it shouldn't sound like you're reading a script. It's important here to speak slowly and clearly. You should maintain a similar pace throughout your submissions. A lot of mooters tend to rush or to speed up when they're running out of time. However, it's really important that you avoid this and remain calm and measured so that the judge can understand you. Some mooting terminology to keep in mind and to get used to. You should always start and end your submissions by saying, "May it please the court." You should address the judge as "Your Honour," or if there are multiple on a bench, "Your Honours." You should call your opponent your learned friend and your co-counsel your learned senior or learned junior. Whenever you are making a proposition, say, "We submit," rather than "I believe" or "I think." And a good way to wrap up your submissions and to signal to the judge that you are concluding and ending is to say, "Your Honour, if I may be of no further assistance." Those are our submissions. May it please the court. You may notice there that I took a bit of a pause between saying, "If I may be of no further assistance," and the concluding segment, "May it please the court." The reason why I took a pause there is to signal to the judge that that is the end of my submission.
On to the structure. You should always begin a moot with an introduction. However, there are many views as to what the best introduction is, and it's ultimately a matter of personal preference. Most introductions will contain a brief synopsis of the fact, and a good tip is that you don't have to be objective with your summary of the facts. You're entitled to give the facts a slant to your side, but don't be so subjective that you undermine the legitimacy of what you're trying to say. After a factual introduction or a description of your argument, you'll then go on to summarise what the points you'll be making in the course of the moot are. You might say, "Your Honour, I have two submissions. First is that," and then outline the submission. And then second is that, and then outline your second submission. It's also useful at this point to explain the interrelationship between your two submissions, or however many submissions you have. You may say, "or alternatively," or you may say, "in any event," in introducing your second or third submission. And then at the end of your introduction of your submissions, however many they may be, you can then say, "This court only needs to be with us on one of those submissions for the plaintiff to succeed in this case." Or it may be, "This plaintiff need only be with us on the first submission and then one of the two alternatives for us to succeed," to lay out to the court that even though you may have a number of arguments, only one of them may be sufficient for your side to win. That is a very powerful statement to make to the court. After you have introduced your submissions, you will then head straight into your first submission. When heading into that submission, you should also start by giving a summary of what you're going to say. So for example, your submission is, "Our submission here is that the plaintiff was an alien at the time that they were deported by the minister." And then you might say, "We say that he was an alien for three reasons: first, second, third." And then you've given a structure, even within your structure, of what you're going to say. And that gives the judge great clarity about where you're going, and it can also help to structure your own thinking so that you yourself understand how the argument works. When you are concluding your submission, you should also make sure that you summarize what you've just said. So for example, you could say, and therefore, because of the 3 reasons that we have outlined, on our submission, the plaintiff was an alien. Moving next to our second submission, so that gives the judge an idea, okay, this is over. If I have any more questions to ask, I can ask them now, and I'm moving on. You don't want to shock the judge, and the judge say, well, hang on a second, are you on your second submission now? You want to be very, very clear and give them the opportunity to ask any questions that they might have.
On questions. At any time during your oral submissions, the judge can interrupt you and ask a question. There are 4 types of questions that a judge could ask you. First are legal questions, and this is questions or clarifications on what the legal test is. Second are procedural questions, which are questions on standards and burden of proof, and questions about court power and the jurisdiction of this court. Third are factual questions. These are questions about the interpretation or the application of the facts to your case or the law. Fourth are hypothetical questions, where a judge may pose a hypothetical scenario to you to test the limits of your proposition. It is really important here that when you're answering a question, to answer it directly. Remember that if it is a yes or no question, make sure you answer with a yes, a no, or a not quite, followed by an explanation. The best types of answers cite authorities to back up their proposition and are succinct and structured. Remember to remain calm and composed, like always, during your question answering. After you answer the question, try your best to transition back into your prepared oral submissions. And if you can do this seamlessly, that will really impress the judges and score you high marks. Now, onto some examples of question answering. In this section, I'll be acting as a judge and Rob will be acting as counsel. An example of a legal question may be, counsel, what is the statutory framework that this court should be applying?
Your Honour, this court should apply Section 5B of the Civil Liability Act, which outlines the test for breach of duty of care. To establish breach, the appellant must satisfy 3 factors.
An example of a factual question may be something like this. Sorry, counsel, wasn't your client's email sent on the 8th of August?
No, Your Honour, the email in reply was sent on August the 9th, as is clear at paragraph 10 of the agreed facts, whilst the initial email was sent on the 8th of August. The reply email from our client was only sent the subsequent day.
An example of a procedural question may be, counsel, what is the standard for overturning a finding of fact?
This court may only overturn a finding of fact if that finding is proven wrong by incontrovertible facts or uncontested testimony, or alternatively, if the initial finding was glaringly improbable or contrary to compelling inferences. And that was the standard laid down by the High Court in its 2003 decision of Fox and Percy by Justices Gummo, Kirby, and Chief Justice Gleeson. Remember that you can only dispense with formal citations by asking, Your Honour, may we please dispense with formal citation? And even at that point, you must still be sure to give the name of the case, the court which decided the case, and the year in which it was decided. Do be cautious though, that sometimes judges will not allow you to dispense with formal citation, and you should be sure that you do have the formal citations for each case which you seek to rely upon, in case a judge decides that they don't want to let you dispense with them.
Thanks everyone for following along. You can see examples of moots on the SULS YouTube page, as well as more advice on mooting and competitions in the Competitions Handbook, and on the SULS website. Thanks for watching our videos, and you can check out the other 2 videos in this series on written submissions and how to deliver appearances on the SULS YouTube page. Best of luck with your competition. Bye.
Bye.